Hello, everyone, and welcome to Uncivil Law. I hope you are having a great day. And my channel name becomes more and more accurate with every passing day. Uncivil Law. Well, why would we have to talk about uncivil side of law? Well, let me think what might be happening that might be causing that to happen. Yeah, so who knew how well positioned I was for the upcoming whatever this is. But we are today with regular normal law. We're here today with the case decision of Allen versus Cooper. Now, this came out the other way than I expected. I was thinking it would come out 8-1 to reverse, but no, it was 9-1 to affirm. And the central reason I was wrong is I was predicting that they were going to overturn a prior decision that was basically guiding in this Florida prepaid. I thought North Carolina went too far. I thought that they basically pushed the envelope well past the point of breaking. I think I said 8-1, but whatever. I said 8-1. It was in fact 9-0. But yeah, I thought they pushed it too far once that they went past the point of breaking, and I thought the Supreme Court would wind up reversing Florida prepaid in order to have this case come out the other way. But I predicted wrong. They upheld the precedent, which I suppose in retrospect was the safer bet. Precedent is fairly rarely overturned. It happens maybe 2-3 times a year, so it's not like unprecedented. But all else being equal, I should have assumed the precedent would have been upheld. So in retrospect, my optimism on it coming out the other way was a bit overly optimistic. So I think that was more of a miscalculation on my part rather than me being fundamentally wrong, if that makes a sense. Like, I was right on all the details. I just weighed them out wrong, if that makes any sense, rather than me being wrong about something in like a element of it. So it wasn't that I missed something, it's that I weighted it wrong, if that makes sense. Something to take home. Anyways, we're going to read the decision, because why not? We're going to read the decision. It's only 21 pages long, and we're going to read it and see what we do it. This is about no, this is not about the copywriting of law. That is Georgia. That case was Georgia trying to copyright its own law. This case is about North Carolina trying to steal the copyright of someone else, and they can. And so, as we sort of joked on the live stream, I guess we can look forward to Calflix and 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 Kakalaki Flicks and all the rest of it, because apparently they can just start streaming services and put up all the movies they want, and they can't be sued. So, good times. But let's just read it. Let's read the whole thing and see what happens. Now, Jan says, you see, most channels have been down 20 to 30% because YouTube unleashed a new algorithm. Well, Jan, if you know anything more about it substantively in terms of how I can make the algorithm happy, please let me know, because I'm here to please my algorithm masters. So let us read this unanimous decision from the Supreme Court and see what we think. See if we disagree with it, and we'll certainly understand the law one way or the other. Normally, like when I cover these things, I just read the syllabus, but I want to talk for a while, so we're just going to read the whole decision. So let's just read the decision. Why not? Justice Kagan delivers the opinion of the court. In two basically identical statutes passed in the early 1990s, Congress sought to strip the states of their sovereign immunity from patent and copyright infringement suits. So the issue was sovereign immunity. Can the state be sued because they're the sovereign? So we knew that. Not long after they passed it, the court held in Florida prepaid that the patent statute lacked a valid constitutional basis. Today we take up the copyright statute. And these things do also usually go in pairs. Not always, but more often than not, substantially more often than not, what is true in copyright law is true in patent law and vice versa. There are obviously a number of material differences, but they have been like twin compared for forever. So all else being equal, they do tend to follow each other, which is another reason I should have gone the other way in my prediction. We find our decision Florida prepaid compels the same conclusion. So basically, we were right in the copyright case, and therefore, mutus mundus will just apply it here. Okay, that, as a rationale goes before, you have to be mainstream before, and you have to be huge mainstream. Well, I may be out of luck. Yeah, Jan, I'm getting better and better with every passing day. So now let's learn a little bit about the facts. In 1717, the pirate Edward Teach, better known as Blackbeard, captured a French slave ship in the West Indies and renamed her the Queen Anne's Revenge. Great name. The vessels became his flagship. Carrying 40 cannons and 300 men, the Revenge took many prizes as she sailed around the Caribbean and up the North American coast. But her reign over the seas was short-lived. In 1718, the ship ran aground on a sandbar a mile off of Beaufort, North Carolina. And I'd like to be noted for the record, that pronunciation is correct. There is a town by the same exact name in South Carolina, which is pronounced Beaufort. But I can tell you with absolute certainty that the North Carolina one is called Beaufort. So I know that one for sure. Beaufort, North Carolina. Don't let anyone tell you I'm wrong. Blackbeard and most of his crew escaped without harm. Not so on the Revenge. She sank beneath the waters where she laid undisturbed for 300 years. In 1996, a marine salvage company named Intersol, Inc. discovered the shipwreck. Under federal and state law, the wreck belongs to North Carolina. Sure, why not? It's in South Carolina. It's in North Carolina's waters, so sure, it belongs to North Carolina. That's fine. The state contracted with Intersol to take charge of the recovery activities. Intersol, in turn, retained petitioner Frederick Allen, a local videographer, to document the operation. For over a decade, Allen created photos and videos of his divers' efforts to salvage the Revenge's guns, anchors, and other remains. He registered copyrights on all the work. Another reason I thought this would go the other way is because I thought this would be a breach of contract issue rather than a copyright issue. So maybe the court will get into that on why it's not a breach of contract issue. I think it's because the state of North Carolina, like as a matter of state law, said you don't have a contract anymore, which I think makes it kind of an equal protection argument. So maybe the court will get into that. So I guess he loses on his contract claim because North Carolina just abrogated his contract. One of the benefits if you're the state, I guess. But there's an equal protection element in there too. This suit arises from North Carolina publication of some of the videos and photos. Allen first protested in 2013 that the state was infringing his copyright by uploading the work to its website, that'd be North Carolina's website, without permission. To address the allegation, North Carolina agreed to pay a settlement paying Allen $15,000 and laying out respective rights. Again, another reason I thought it would go out the other way. We have the initial contract, and then we also have a settlement agreement, which itself is a contract. So we have two contracts. Another reason I thought it would go the other way. But Allen and the state found themselves involved in another dispute. Allen complained that North Carolina had impermissibly posted 5 of his videos online and used one of his photos in a newsletter. When the state declined to admit wrongdoing, Allen filed this action in federal district court. It charges the state with copyright infringement, some called a modern-day form of piracy. Ha ha ha. We all get the joke. Ha ha ha. You have to appreciate the humor, man. This is as much humor as we get in Supreme Court opinions. So, that one is a knee slapper. We have to do with this. And seeks money damages. North Carolina moved to dismiss the suit on ground of sovereign immunity. It invoked the general rule that federal courts cannot hear suits brought by individuals against non-consenting states. Fair enough. But Allen responded that an exception to the rule applied because Congress had abrogated state sovereign immunity from suit like this. The Copyright Remedy Clarification Act of 1990 provides that the state shall not be immune under the 11th Amendment or any doctrine of sovereign immunity from suit in federal court for copyright infringement. And the Act specifies that in such a suit, the state will be liable and subject to remedies in the same manner and to the same extent as a private party. That meant Allen contended that a suit against North Carolina could go forward. Well, that text does sound pretty good for him. I mean, it does sound pretty good. So, if I were his lawyer, I'd walk in with that argument. But there's a statute that says exactly this. Pretty good argument. Can't deny that one. The district court agreed. Of course they did, because it's pretty clear in its text. Quoting from the text, the court found that Congress has clearly stated its intent to abrogate sovereign immunity for copyright claims against the state. And in that abrogation, the court next held it had a proper constitutional basis, because you would need one, because of federalism. Florida prepaid and other precedent the district court acknowledged precluded authority from using its Article I power, including its authority over copyrights, to take away sovereign immunity. Fine. But in the court's view, Florida prepaid left open an alternate route, Given the state's pattern of abusive copyright infringement, the court held, the Congress could accomplish its object under Section 5 of the 14th Amendment. That does sound a lot more promising. Right? Because I said, well, equal protection. And this is an equal protection argument. And you're looking for the basis. Now, equal protection itself is what, Clause 2 of the 14th Amendment? But Clause 5 of the 14th Amendment is the one that says, and Congress can make laws pursuant to this. So it's an equal protection argument. It's saying we have equal protection, and oh, by the way, Congress can make laws, and they did. So we have an equal protection claim. So it's an equal protection argument. So like the district court says, oh, okay, you can anchor this, and that was not a pun. That was just, wow. You can anchor this in Section 5 of the 14th Amendment to get you to Section 2 of the 14th Amendment to get you to equal protection. Okay, I mean, that seems pretty reasonable to me. I understand the district court's analysis. That makes sense. On interlocutory appeal, the Court of Appeals for the Fourth Circuit reversed. It read Florida Prepaid to prevent the recourse to Section 5, no less than Article 1. That's a strangely constructed sentence, but it just means they're equally not effective. Section 5 abrogation, the court explained, must be congruent and proportional to the 14th Amendment inquiry it seeks to remedy. Florida Prepaid had applied that principle to reject Congress's attempt in the Patent Remedy Act to abolish states' immunity from patent infringement suits. We might have to go back and read Florida Prepaid, because they're stating a principle of law in a very summary way, which is fine because it's a previously established summary of law. They're not like establishing it here, but I don't know what that means because I don't know if I ever read Florida Prepaid, and if I had, I've forgotten what that is. To be congruent and proportional. I read that, I'm like, I don't know exactly what that means. So maybe we'll have to go back and read it. Maybe we'll read it tonight. Why not? We've got time. We'll see how my energy level keeps up. Since my governor is going to declare a lockdown tomorrow, I figure I might as well be here and enjoy this. Okay. The abrogation the court reasoned here was equally broad and rested on a similar legislative record, constitutional harms. So Section 5 cannot save the law. Well, that part I would agree with. Motus mundus, one would apply for the other. So if it was true in Florida Prepaid, it would be true here. Now, again, I thought like it was so extreme what North Carolina did that they overruled Florida Prepaid. And I'm still interested in the breach of contract. So the breach of contract doesn't work because North Carolina just killed your contract, and contracts are a matter of state law. The 14th Amendment doesn't apply because of this doctrine under the patent law, but there's still a 14th Amendment equal protection argument for the contract. Maybe? I don't know. I don't know if the court's going to get into it, but there's like another avenue here. Maybe. All right, let's continue on. In our constitutional scheme, a federal court generally may not hear a suit brought by any person against a non-consenting state. That bar is nowhere explicitly set out in the Constitution. The text of the 11th Amendment, the single most relevant provision, applies only if the plaintiff is not a citizen of that defendant state. But this court has long understood the amendment to not stand so much for what it says as for the broader presupposition of our constitutional structure, which it confirms. So the 11th Amendment goes further than its text would suggest. Okay, I guess that's strange, but fine. At least it's better than like when they're killing off provisions of the Constitution, which they've arguably done other places. At least they're here saying it stands for more than it says. So that's a little bit better. The premise has several parts. First, each state is a sovereign entity in our federal system. Yes, every state is sovereign. It's, we've talked about state sovereignty many, many times in this channel. It's not just me who uses that language. The Supreme Court of the United States also uses that language. The U.S. Supreme Court also believes in the concept of state sovereignty. So all the people who say like, oh, I'm like just dog whistling or something for the Confederacy, I'm like, well, I don't know what to tell you. The U.S. Supreme Court uses the language state sovereignty too. It's not just me. It is, in fact, a legal concept. Each state is a sovereign entity in our federal system. It is inherent to the nature of sovereignty not to be amenable to a suit absent consent. And last, the fundamental aspect of sovereignty constrains federal judicial authority. Yes, it does. So the federal judicial authority is limited. They can only hear certain kinds of claims. The state judicial authority in some ways is more extensive because the state has police powers and the federal government doesn't. So, yeah. But not entirely. This court has permitted a federal court to entertain a suit against a non-consenting state on two conditions. First, the Congress must have enacted a unequivocal statutory language abrogating the state's sovereign immunity from Seminole Tribe, which seems like it was here. And second, some constitutional provision must allow Congress to encroach. Not even the most crystalline abrogation can take effect unless it's a valid exercise. I like that. Not even the most crystalline abrogation. So even the clearest of the clear, like, a few good men style. Are we clear? We're clear. Are we clear? Crystal. Crystal. So even if we're crystal, it doesn't matter if we don't have authority. I guess that's, all right. No one here disputes that Congress used clear enough language to abrogate the state's immunity. Yeah, it does seem pretty clear. As described above, the CRCA provides that the states shall not be immune from those actions. And the Act specifies the state stand in the identical position to that as a private defendant, exposed to liability and remedies in the same manner to the same extent. So there's now no doubt what Congress meant to accomplish. Congress was clear. Thank you, Congress, for being clear. That was helpful, at least. Indeed, this court held in Florida Prepaid that essential verbatim provisions related to the Patent Remedy Act could not have been made any clearer in the intent to remove the remedy. The contested question is whether Congress has authority to take that step. Fair enough. Allen maintains it did, under either of two constitutional provisions. He first points to the clause in Article 1, empowering Congress to provide copyright protection. Which, you could make that argument, but it's a little weak sauce. Well, it's not entirely weak sauce, but, there are some problems. Because, you're pointing to one section of the Constitution that says Congress can do this, but the Constitution itself also reflects a federalist structure. So it's you have to interpret everything in light of everything else. So there is a bit of a problem there. If that fails, he invokes Section 5 of the 14th Amendment, which authorizes Congress to enforce the commands of due process. And also, I'd argue, equal protection. Neither contention can succeed. The slate on which we ride today is anything but clean. Florida Prepaid, along with other precedent, forecloses the argument. So yeah, that's basically where I lost. That's basically where I lost the analysis. I thought, this is so egregious that they're going to reconsider Florida Prepaid, but I failed to give precedent its weight and due. So that's where I made the miscalculation on that one. So, well, what can you do? Congress has the power under Article 1 to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. I know this language well. It is the basis of my existence. That provision, we call it the Intellectual Property Clause, sure, enables Congress to grant both copyrights and patents, and the monopoly right so given imposes a corresponding duty, not to infringe on states no less than private parties. Oh my God. Tiberius. Wow. Oh, wow. Wow. Jan, Jan, I'm going to leave it to you to decide whether or not to time out Tiberius. That was a low blow, man. That was a low blow. Oof. In Allen's view, Congress's authority to abrogate sovereign immunity from copyright suits naturally follows. Abrogation is the single best, or maybe he says only way for Congress to secure the copyright holder's exclusive rights against state intrusion. See brief for petitioners. Jan says yes. Good times. The problem for Allen is this court has already rejected his theory. The Intellectual Property Clause, just noted, covers copyrights and patents alike. So, as the first place, the Florida Prepaid Court looks when deciding whether the Patent Remedy Act violently strips the states of immunity from infringement suits. In doing so, we acknowledge the reason for Congress to put the states on the same footing as private parties in patent litigation. It was, just as Allen says here, to ensure a uniform, surefire protection of intellectual property. It is 300 seconds. I wish it was shorter. I wish it was shorter. I wish you could time people out for shorter than 300 seconds. But yeah, it's 5 minutes. So Tiberius can think upon his sins for 5 minutes. Oh well. We love you, Tiberius? Question mark, question mark, question mark. That was a proper Article 1 concern we allowed, but still, we said Congress could not use Article 1 power or powers to remove the state immunity. We based our conclusion on Seminole Tribe, decided 3 years earlier. There, the court had held Article 1 cannot be used to circumvent sovereign immunity placed under federal jurisdiction. Okay, fair enough. Because Congress could not abrogate state sovereign immunity under Article 1, Florida Prepaid explained the Intellectual Property Clause could not support it. Okay, fine. So none of the Article 1 powers abrogate state sovereign immunity. Okay, I mean, that makes sense because the concept of state sovereign immunity is kind of baked in there. So that sort of makes sense. How much money do I need to give you to do a video on jury nullification? Well, Zacharia.org, my standard policy right now is I will take, for a $20 super chat, I will review any decision from a court. So if there is a decision that you want me to review, then I'll review that. If you want me to do something like discussing the concept of jury nullification, then I'll need to think of like a higher price because it involves more conceptual work. But if there's a specific case you want me to review, $20. Allen claims, however, that later case offers an exit ramp. In Central Virginia Community College versus Katz, we held Article 1 bankruptcy clause enables Congress to subject non-consenting states to bankruptcy proceedings, there to recover a preferential transfer. We thus exempted the bankruptcy clause from Seminole Tribe's general rule that Article 1 cannot justify hailing a state into federal court. In bankruptcy, we decided sovereign immunity has no place. But if that's true, Allen says, why not say the same thing here? Fair. Allen reads Katz, adopting a clause-by-clause approach to evaluating whether a particular clause of Article 1 allows abrogation of sovereign immunity. And claims the Intellectual Property Clause supplies a singular warrant for Congress to take that step. That is so, Allen reiterates, because Congress cannot secure exclusive rights if their power is to make states pay for infringing construct. Okay. But everything in Katz is about and limited to the bankruptcy clause. The opinion reflects what might be called bankruptcy exceptionalism. I like that. That's like, will you give legal advice for a $500 super chat? So long as you are not going to use it anyway in any sort of court proceeding, sure. This was unanimous. There was no dissent in this particular opinion. In part, Katz rested on the singular nature of bankruptcy jurisdiction. Jurisdiction is and was in the founding principally in rem, meaning against the property, meaning it was premised on the debtor and his estate, not on the creditor. That is a person, not on the creditor, meaning his person. So it's on the debtor and estate, the property, not on the creditor, meaning the person. For that reason, though, it does not implicate the state's sovereignty to the same degree as other kinds of jurisdiction. I'm not sure I fully agree with that concept because property is an issue of state law too. Like who owns what property is state law. So I'm not sure it quite follows that a state's interest in the person is less than the state's interest in the property. If a federal court is ruling on like property in Texas, property is a matter of state law too. So I'm not quite sure it quite follows. But okay. The clause emerged from a felt need to curb the state's authority. The states, we held, had wildly divergent schemes for discharging debt and offered and refused to respect one another's discharges order. The framers' primary goal in adopting the clause would address the problem, stop competing sovereigns from interfering with the debtor's discharge. And in that project, the framers intended federal courts to play a leading role, in fact, the only role. The nation's first Bankruptcy Act, for example, empowered the courts to order the states to release people they thought were being held in debtors' prisons. So through and through, we thought the bankruptcy clause embraced the idea that federal courts could impose on state sovereignty. It was sui generis, which is a very fancy word for we're making it up as we go along. Please stop asking us further questions. Again, it was unique among Article 1's authority. Indeed, Katz's view of bankruptcy clause had a more even striking aspect, which further separates it from any other. Okay, exceptionalism, I guess, for sure. The court may have concluded from its analysis that the clause allowed Congress to abrogate the state's sovereign immunity, as Allen argues in the intellectual property clause. But it did not. Instead, it went further. Relying on the above account of framers' intention, the court found the bankruptcy clause itself did the abrogating. Okay, fine. So they're saying the clause itself, in other words, it was baked into the constitutional structure from square one. All right. The relevant abrogation is the one effected into the plan of the Constitution, so that the clause itself was the abrogation. That's a creative reading of the bankruptcy clause, but okay. I mean, I'm not saying that I disagree with the end result, but it's to give that clause that much color. It's like, okay, well, all right, that's the law. We decided no congressional abrogation was needed because the states had already agreed in the plan of the convention not to assert any sovereign immunity defense in the bankruptcy proceedings. We therefore discard our usual rule, which Allen accepts as applying here, that Congress must speak, and indeed speak unequivocally, to abrogate sovereign immunity. Our decision, in short, viewed bankruptcy as on a different plane, governed by principles all its own. Well, holy Lord, man. The home is special, and apparently bankruptcy is special. It's on a different plane of existence. There's the rest of the Constitution and the bankruptcy clause. Okay, it's on an entirely different plane of reality. We are not worthy. We are not worthy. We all say together, like the bankruptcy clause. Okay. Nothing in that understanding invites the kind of general clause by clause re-examination of Article 1. To the contrary, it points to a good for one clause only holding. So this is special. This applies only this one time. Do not look behind the curtain. Newt says more important than free speech. I don't know, man. At this point, I don't know, man. I don't know if it's more important than free speech. Because I didn't know there were different planes. But apparently bankruptcy is on a different plane. So I don't know what plane the First Amendment is on. I have nothing to offer on it. On the First Amendment's relative importance to the bankruptcy law. These were questions I didn't know I was asking before, but apparently these are questions I was supposed to be asking. And even if Katz's confines were not so clear, Florida prepaid, taken together with stare decisis, would doom the argument. Well, Jesus, man, doom is a little strict. I mean, stare decisis, can change. I guess we're not going to, but to say it would doom the argument, man, Lord. Zachariah Ong says, are there any ideas that are held above the Constitution itself, like popular sovereignty, judicial review, precedent, rule of law against arbitrary power? Probably. I suppose the chief idea above the Constitution is the idea that the people, as a collective whole, are sovereign, which I suppose the Constitution itself does say. But the idea that the people, as a collective whole, can do whatever they like, I guess does beat the Constitution. Because, lest we forget, the people as a collective whole, overthrew the previous Constitution, the Articles of Confederation, and the people as a collective whole overthrew the Constitution before that, otherwise known as being part of the United Kingdom. So, yeah, the people as a collective whole can do anything they like. So, yes, I suppose that beats the Constitution. So yeah, I suppose that is on top of it. But the Constitution itself does reflect that. It does start "we the people," so not like the Constitution ignores it, but yeah. And there's also like just the idea that the republic busted door. So you've heard that say that the Constitution is not a self-ending agreement. So If the needs need bend, then Constitution will bend to the ongoing solidity of the state or something. But yeah. If your question is alluding to the eventual possibility of martial law, I will simply note here that we probably should cover it on a later stream. It would be ex parte Milligan, but essentially, as long as the courts are operating, we can't have martial law. And given technology that's available to us, that's a lot easier than was. I mean, we'd have to bend court procedure into pretzels, but I suppose there's nothing fundamentally like unconstitutional about like courts doing things by email and Skype and phone calls. Be weird. We'd have to bend procedure, but it wouldn't be unconstitutional. So, technology gives us a lot of latitude. So that's a plus. As Allen recognizes, if the Intellectual Property Clause permits the abrogation, also permit the Patent Remedy Act. Again, there's no difference between the copyrights and patents under the clause, nor a material difference between the two statutes provisions in this respect. So we'd have to overrule Florida prepaid if we decide this case Allen's way. But stare decisis, this court has understood, is a foundational stone of the rule of law. To reverse a decision, we demand special justification over and above the belief the precedent was wrong. Allen offers nothing of special at all. He contends only if the courts were to use a clause-by-clause approach, it would discover Florida prepaid was wrong. And with that charge of error alone, Allen cannot overcome stare decisis. So the power of stare decisis wins the day. Courts could do video. Yeah. I think courts can bend procedure pretty far and be constitutional. I think video calls, it's not like they don't already do it for like suspects that are particularly dangerous. They won't necessarily bring them in the courthouse. So video conferencing is probably okay. Doing things electronically is probably okay. You can bend pretty far. You can bend pretty far if you have to. I don't think you have to delay the election. I know the Democratic Party, I think, is talking about, if they haven't already, talking about delaying the primaries. But the Democratic primaries are mostly private. They're administered through the state, but they're really a private organization. So, like, the Democratic primaries are kind of like, the Democratic Party can kind of do what it wants. So it's like, the primaries are the primaries. They can just kind of make up their own rules. They're private organizations, whatever. As to the election in November, there's really probably no need for that. First of all, hopefully this thing will be over by then. One can only hope. Second of all, everyone has a really ready-made excuse for mailed-in voting. Even for cause, mailed-in voting, it's like, what is your cause? I can't make it to the polls. Why? Cause quarantine. So we can do the whole thing by mail. So we got that going for us. And, even if, like, for some reason we couldn't do that, one of the benefits of the Electoral College is that, technically speaking, the election, in terms of the people voting, is technically optional. Because the Constitution says the states shall choose their electors. So as long as the state government is up and running, I guess, hypothetically, they could not have an election, and it would be illegal. They could just, like, choose somebody. That'd be weird. But yeah, I don't think we're near that. I think we have alternate remedies. Section 5 of the 14th Amendment, unlike almost all of Article 1, can authorize Congress to strip states of immunity. The 14th Amendment fundamentally alters the balance of state and federal power. It sure does. The first section imposes prohibitions on the state, including, as relevant here, that none may deprive a person of life, liberty, or property without due process of law. Section 5 gives Congress the power to enforce those limits. The power the court has long held may entitle Congress to abrogate state immunity and thus subject them to federal court. For an abrogation statute to be appropriate under the fifth, under Section 5, it must be tailored to remedy or prevent conduct infringing the 14th Amendment substantive prohibitions. Okay. Congress can permit suits against states for actual violations of the rights guaranteed in Section 1. And to deter those violations, it can allow suits against states for a somewhat broader swath of conduct, including acts constitutional in themselves. But Congress cannot use its power to enforce the 14th Amendment through the 14th Amendment to alter what the amendment bars. That means congressional abrogation is valid only if it sufficiently connects to the conduct courts have held the Section 1 to prescribe. Yeah, Zachariah is reasonably right. And like that's also like where the power of government comes from in our republic. Like why the whole concept of rule of law is everything treads on popular consensus fundamentally. So it's like people are willing to obey these orders from these government to varying degrees, but they're willing to obey the orders because people believe in the rule of law and they believe in it. So it's like, yeah, everything treads on a water of consensus. So the Supreme Court, and for that matter, pretty much the entirety of government gets its power from the ongoing consensus of the people. It's kind of cool, actually. Yeah. To decide whether a law passes muster, the court has framed a type of means end test. For Congress action to fall within Section 5, we've said there must be a congruence and proportionality between the injury prevented and the remedy and the means adopted. On the one hand, courts are to consider the constitutional problem Congress faced, both the nature and extent of the state violations of the 14th Amendment. That assessment usually, although not inevitably, focuses on the legislative record, which shows evidence Congress had before of a constitutional wrong. On the other hand, courts are to examine the scope of the response Congress chose to address the inquiry. Here, a critical question is how far and what reasons Congress has to go beyond redressing actual constitutional violations. Hard problems also often require forceful responses. Excuse me. And as noted above, Section 5 allows Congress to enact reasonable prophylactic legislation to deter constitutional harm. I always chuckle a little when the court uses the word prophylactic. Nice. Strong measures appropriate to address one harm may be unwarranted response to another lesser one. Always, when Congress has done, must be in keeping with the 14th Amendment rules it has the power to enforce. All this raises the question, what does the 14th Amendment care about copyright infringement? Sometimes, no doubt, copyrights are former property, and the 14th Amendment bars states from depriving a person of property without due process of law. But even sometimes, by no means always. Under our precedent, a merely negligent act does not deprive a person of property. Well, I don't know if the courts is going to get into it, but I think North Carolina did arguably a little bit more than merely negligent behavior. Yeah. So an infringement must be intentional, or at least reckless, to come within the reach of due process. And once more, a state cannot violate the clause unless it fails to offer an adequate remedy of infringement because such a remedy itself satisfies due process. That means within the broader world of state copyright infringements is a smaller one in which the due process comes into play. Because the same is true of patent infringement, Florida Prepaid again serves as critical precedent. That decision defined the scope of unconstitutional infringement in line with the cited case law above, intentional conduct for which there's no adequate state remedy. It then searched for evidence of the sort of infringement in the legislative record of the Patent Remedy Act, and determined that the statute's abrogation of immunity, again the equivalent of the CRCA's, was out of all proportion to what it found. That analysis is the starting point of our inquiry here, and indeed it must be the ending point too, unless the evidence of unconstitutional infringement is materially different for copyrights rather than patents. Considering once more, then, Florida Prepaid, now not on Article 1, but Section 5. Yeah. In enacting the Patent Remedy Act, Florida Prepaid found the court did not identify a pattern of unconstitutional patent infringement. To begin with, we explain there's almost thin evidence of statute states infringing patents at all, putting aside of whether those actions violate due process. The House report recognized many states comply with patent law, offering just 2 examples of patent infringement suits against states. The appellate court below, boasting some greater research prowess, discovered there are 7 in the century plus between 1880 and 1990. Even the bill house's sponsor conceded the lack of any evidence of widespread violation of law. What was more, there was no evidence of any instance of infringement by states that crossed constitutional lines. Congress, we observed, did not focus on intentional or reckless conduct. To the contrary, the legislative record suggested that most state infringement was innocent or at worst negligent. And similarly, Congress barely considered the availability of state remedies for patent infringement. So we conclude nothing could support the ideas that states were more than sporadically, if that, depriving patent owners without due process. Given absence of evidence, Florida Prepaid held the Patent Remedy Act swept too far. Recall what the Patent Remedy Act did and did not. It abrogated sovereign immunity for any and all patent suits, thereby placing states on the same footing as private parties. It didn't set any limits. It did not, for example, confine the abrogation suits alleging non-negligent infringement or infringement authorized by state policy. Interesting. Okay, so that's an interesting idea there. So basically they seem to be suggesting that if this act was written more narrowly to only apply to intentional conduct, that it would be valid. But it wasn't so broadly, so narrowly construed. Now, you could read the statute to only apply to the narrow case because it's broad language, right? So the narrow case is contained within the broad case, right? So a court could just collapse the statute into the narrow case. But they didn't do that. They just said, oh, it's too broad, and wiped the whole thing out. So I guess they could try again if they really want to and, try for something more narrow. Because arguably what North Carolina did falls into the narrow case. The narrow case is within the text of this thing. But the whole thing covers too much. Okay, I mean, all right, I guess. That's a little weird. Neither did target states refusing to offer alternative remedies to patent holders. No, exposed all states to the hilt, nice language, on a record that failed to show they had caused any discernible constitutional harm, or indeed any harm at all. I know this is a little bit of a personal moment, but I am a little bit disappointed by the algorithm or whatever because I only have 14 viewers right now. So I'm a little sad. I'm happy for the 14 of you who are here. But, I'd like to get more traction. I'd like to get more attention. Viva Fry has like a couple hundred people on his streams. Rokita has like 1,400 people on his streams. I want 1,000 people on my streams. You think with everyone being locked inside and on, because of all this stuff, that there'd be more traffic. Maybe they don't want to learn about law. Or maybe I just need to become like even more political about it. Like I try to be relatively neutral, but I suppose I could like turn more into like a conservative pundit style and just be like, this is a travesty, and just get really like indignantly angry. This is reprehensible. That kind of stuff. So maybe if I go like, conservative talking point and just like inject all kinds of emotion about how this is destroying and snowflakes and blah blah blah. You know the drill. Maybe that would work for my algorithm. I don't know, Jan. The conservatives tend to do pretty well on YouTube, all things being considered. In fact, I've read way too many pieces about how the alt-right thrives on YouTube. This is a bastion of all that's evil is on the YouTube. The state's indiscriminate scope was too out of proportion to any due process problem. It aimed not to correct the problem, but also to provide a uniform remedy for the Patent Act's writ at large. The Patent Remedy Act, in short, did not enforce Section 1 of the 14th Amendment, and so it was not appropriate under Section 5. Could then this case come out differently? Given the identical scope of the statutes, that could happen only if the former law responded to materially stronger evidence of infringement, especially of an unconstitutional kind. I'll see what I can do. I'll see what I can do with Zechariah. But you know how it is. You know how it is, man. If you go right wing, everything is racist, everything is sexist, everything is just code language and dog whistles. So I'm not sure it's actually possible for me to do what you're saying. If I just become more overtly right wing, everyone's gonna say, well, that's really code for racism and Jim Crow and I don't know. Yeah. No. Allen points to a disparity in how Congress created a record for the two statutes. Before enacting the CRCA, Congress asked the then Registrar of Copyrights, Ralph Oman, to submit a report about the effects of the 11th Amendment on copyright enforcement. Oman and his staff conducted a year-long investigation, which included a request for public comment, eliciting letters from 40 copyright holders and industry groups. The final 158-page report concluded that Copyright proprietors have demonstrated that they will suffer immediate harm if they're unable to sue infringing states in federal court. Is that report enough, as Allen claims, to flip the Florida prepaid outcome when it comes to copyright cases against the states? It is not. Yeah. Behind the attempting grabbing conclusion, nothing in the Omen report or the rest of the legislative record cures the problem we've identified in Florida prepaid. As an initial matter, the concrete evidence of states infringing copyrights, even ignoring whether those acts violate due process, is scarcely more impressive than what Florida prepaid saw. Despite undertaking an exhaustive search, Omen came up with only a dozen possible examples of infringement. He listed 7 court cases brought against states, another 2 dismissed on the merits, and 5 anecdotes taken from public comments, but not corroborated. In testifying about the report, Omen acknowledged that state infringement is not widespread, and states are not going to get involved in wholesale violation of copyright laws. Well, so he says, but state with the economy being what it is, I don't know. Can Calflix be well behind? Who else thinks that we're going into like the biggest economic depression ever? It's like, is unemployment going to be 10%, 20%, 50%? How bad is this going to get? Pretty bad. Pretty bad. The bill's House and Senate sponsors got the point. They further admit there had not been a significant number of copyright violations by states, and the latter conceded he could not see a big problem. This is not, to put it charitably, the stuff on which Section 5 legislation ordinarily arises. Ha 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 ha. Yeah, Tiberius, that isn't going to happen. That's not going to happen. Unless he doesn't have to, like, spend anything in, like, unless he doesn't have to spend anything in his stocks. I figure by the time we're done, we're looking at 8 year recovery period. Yeah. I think I lost all my gains in the last 2 years. It's all paper money, but still. Get a roll of TP on me. It's going to be bad. Thank you, Zaval. $2. Yes, thank you very much. And it only gets worse. Neither the Omen report nor any other part of the legislative record shows concern with whether the state's copyright infringement, however few and far between, violated due process. Of the 12 infringements listed in the report, only 2 appear intentional, and they must be to raise a constitutional issue. As Omen testified, the far greater problem was the frequency of honest mistakes or innocent misunderstandings. The benefit of the bill, he therefore thought, would be to guard against sloppiness. Likewise, the legislative record contains no information about the availability of state law remedies for copyright infringement, such as contract or unjust enrichment, even though they might themselves satisfy due process. So this may be ultimately a failure of pleading. This may ultimately be a failure of pleading because, like I've been saying, like, well, maybe he had an idea for copyright or an idea for contract, and I'd have to go back into the record and figure out like the whole thing. But like, maybe he had a cause of action for contract and he could use the contract equal protection argument for 14th Amendment violation rather than the copyright infringement itself, which makes sense also because they came to a settlement. So you could argue violation of license, which is a contract argument. So his argument might have been better rooted in contract than in copyright. So under Florida prepaid, the CRCA must fall to our congruence and proportionality test. As just shown, the evidence of the 14th Amendment supporting the CRCA and Patent Remedy Act is equivalent. For both, that is exceedingly slight. Yeah, fair enough as to that. Scope of the 2 statutes is identical, extending every infringement case against the state. It follows the balanced law strike between constitutional wrong and statutory remedy is correspondingly askew. In this case, as in Florida free prepaid, the law's indiscriminate scope is out of proportion to any due process problem. In this case, as in that one, the statute aims to provide a uniform remedy for statutory infringement rather than to redress or prevent unconstitutional conduct. And so in this case, as that one, the law is invalid under Section 5. That conclusion, however, need not prevent Congress from passing a valid abrogation law in the future. In doing so, Congress would presumably approach the issue differently than when it passed the CRCA. Could another state shut down a border with another state legally? There'd be some reasonable questions as to why you're doing it. I mean, not normally, but we're in trying times. Yeah, we're in trying times. I mean, there's generally agreed to be freedom of movement in general. There's generally agreed to be the right to move from state to state. It's generally thought to be implied in the privileges and immunities clause. So you'd have to show some sort of like truly state harm, and like, yeah. So I guess, but I mean, yeah, yeah. Dormant Commerce Clause, yeah, for sure. Privileges and immunities, Article 4. Dormant Commerce Clause. Dormant Commerce Clause is a nice idea, but I don't think it would work. Privileges and immunities is better. Article 4 is better. But you have got some good ideas. In doing so, Congress would presumably approach the issue differently than when passed the CRCA. Also, if one state is closing its borders to another state, I would presume that the states could sue each other, and then you get original jurisdiction in the U.S. Supreme Court. So you could skip a whole bunch of steps if you wanted to. So there's that. You could try that too. At the time, Congress had not yet described Seminole tribes, so Congress probably thought Article 1 could support its all-out abrogation of immunity. And to the extent it relied on Section 5, Congress acted before its court created the congruence and proportionality test. For that reason, Congress likely did not appreciate the importance of linking the scope of the abrogation to the redress or prevention of the unconstitutional injustice and creating a legislative record to back up the connection. But going forward, Congress will know the rules. Haha, cute. And under them, if it detects violation of due process, it may enact a proportionate response. That type of tailored statute can effectively stop states from behaving as copyright pirates. Even with respecting constitutional limits, it can bring digital blackbeards to justice. Court cannot avoid the pun. Florida prepaid all but pre-wrote our decision today. That precedent made clear Article 1's intellectual property clause could not provide the basis for abrogation, held Section 5 of the 14th Amendment could not support abrogation. For both these reasons, we affirm below. And then there's a Justice Thomas opinion, which is a couple pages. We'll see what we got here. I cannot join his opinion in its entirely. I write separately note two disagreements and one question that remains open for the future. Although I agree Florida prepaid is binding precedent, I cannot join the court's discussion of stare decisis. That court claims we need special justification. That approach does not comport with our judicial duty. If our decision in Florida prepaid were demonstrably erroneous, the court would be obligated to correct the error regardless of whether other factors came in. Nice. Here, adherence to precedent is warranted because petitioners have not demonstrated our decision in Florida prepaid is incorrect. The court in Florida prepaid correctly concluded Congress may not abrogate the power, including powers under the intellectual property clause. Petitioners claim to the contrary are unpersuasive. I do not join the court's discussion regarding future copyright legislation. In my view, we should opine only on the case before us. We should not purport to advise Congress on how it might exercise legislative authority, nor give our blessing to hypothetical statute or legislative records not at issue here. Well, that is a fair point. That is a fair point and a fair rebuke from Thomas. So, fair enough. I believe the question of whether copyrights are property within the meaning of the 14th Amendment remains open. Very nice. Court relies on Fox Film to conclude copyrights are form of property, but Fox Film addressed property in the context of state tax law, not due process. And although we stated in Florida prepaid that patents are property for due process purposes, we did not analyze the 14th Amendment text. Near cases we cited involve due process. Because the parties agree with the petitioner's copyrights are property, and because the 14th Amendment does not authorize the statute abrogation of sovereign immunity, we need not resolve this open question today. I'd, however, be willing to consider it, and therefore, I join the court. Okay. And there's actually like the one patent law decision from a year or two ago that argues it's more of a license than property as such. So then it may not be property. And if it's not property, then presumably Congress could retroactively lower the copyright guarantee, and it wouldn't be a taking. So that'd be nice. That'd be good. Congress passes a statute lowering the term of all copyrights, including those that currently exist, to 50 years from the date of creation, and Disney et al. Get really pissy and sue and say it's a taking, and then they say, well, no, it's not, because it's not property. That decision from a year, 2 or 3 ago, in the patent law context, would argue the patent is more of a license than property, even if it's so. Yeah, it could be a thing that could be fun. All right. Yeah. Well, for the 13 of you who are joined us, I really appreciate your time. Thank you for being here and joining the stream. As always, if you like it, hit the like button, subscribe, tell your friends. We'll keep posting content. We'll see how it goes. See if I continue to live. See if I don't die from the situation. That'd be that. So until later, my friends, I hope all's well. Cheers and goodbye.